2022 DM 216. Jordan Martin appears representing herself. Henry Matlock appears with his attorney, Patrick Blanchard. Joshua Andrews appears as court-appointed guardian ad litem for the child. This matter comes before the court at this time for further proceedings. This court now is in receipt of recommendations of the guardian ad litem following his investigation. I trust this has been shared with each of the parties in this case. I will ask each party for their remarks regarding this recommendation and report and where we need to go from here. I'll start off with Mr. Blanchard on behalf of Henry.
Yes, Sharon, thank you. Yes, we've read the recommendation of Mr. Andrews, and it's our request that the court adopt the recommendations as the orders of the court. He did make reference to the adopting the parenting plan that was attached to the order that was filed with court on September 23rd. We ask that that be followed as well, Your Honor. We're pleased with the schedule. The parties are communicating by our family wizard now, and it's our hope that once this is settled, that the parties will work together in Lurie's best interest. That'll be our obligation and our attempt to do so, Your Honor.
Very well, Mr. Blanchard. I understand your position. Jordan?
What the guardian ad litem typed up didn't quite make sense to me because it said from Mondays to Wednesdays, something about those days being one or the others, but then also the other party gets her on Wednesdays and Fridays, and then something about the weekend. I'd just like for that to be clarified on what that schedule would actually look like.
You know, I'm happy to do that, or perhaps Mr. Andrews would want to clarify that. Either way is fine.
Okay.
I'm happy to do it, Your Honor.
All right.
Yes. Yes, my understanding, and of course, because Mr. Andrews and I work in this every day, it would be that mom would get every Monday and Tuesday, Monday starting at 3 o'clock or after school until Wednesday at 3 o'clock or after school. And father would have every Wednesday night and Thursday night from 3 o'clock or after school until Friday at 3 o'clock or after school. And then on mom's weekend, she would have the child at 3 o'clock or after school until Monday at 3 o'clock. And on dad's time, his weekends, he would have the child after school on Fridays at 3 o'clock or after school until Monday at 3 o'clock. And that schedule would go, the alternating weekends, every other weekend would be mom's and every other weekend would be dad's.
Jordan, I don't see that there's any real crossover. It does appear that each part of the week is set aside specifically to an individual parent. So after Mr. Blanchard's recapitulation of Mr. Andrews' recommendations, do you have any further questions regarding it?
Yeah, that seems a little hectic with her also being in school and all the back and forth, and that seems like a lot going on. And we have to like make sure that we keep track of all of each other's stuff to get it back and forth to where it belongs at the right house. And that's already a lot as is for the Mondays and Wednesdays.
Why did you not consider a week-to-week plan, Mr. Andrews?
Your Honor, I know that was what the father was recommending. Frankly, I felt like that was a lot of time away from each parent, and I wasn't trying to make, even though I didn't give a lot of credence, I think, to some of the more extreme concerns that both parents were leveling, I guess, towards the other. I felt like a more frequent back and forth would maybe be beneficial towards alleviating some of those concerns that they would be able to see the child, make sure the child was okay, after the other parent's parenting time. And given the fact that Mr. Matlock was already receiving Wednesday overnight to Thursday mornings and then every other weekend, it seemed like it would just be a natural progression for his parent time to go Wednesday night through the weekend or Friday evening, and that Ms. Martin would continue to receive the Mondays and Tuesdays through Wednesday, or Monday evening through Tuesday, or Wednesday evening that she's already receiving.
Mr. Andrews, was the young age of this child a factor in that decision as well?
I I think that I'm a little bit more open to the longer periods of time for older children, but with younger children, again, to be honest, in my personal practice, I usually start out with the recommendation of a rotating 223 because that really minimizes the amount of time that the child is away from a parent. But in this particular case, I thought that that may be too much back and forth, too much to keep track of. And again, with the way that the temporary parenting plan was already set up, it just seemed like a static 223 where it was always Monday, Tuesday with one parent, always Wednesday, Thursday with the other. And again, in this case, where Mr. Matlock was already receiving Wednesday overnight to Thursday morning, it just made a lot of sense, even though it results in kind of a 5 days in a row with one parent if they have the weekend. It still, I think that given Lyric's young age, as long as it is a schedule that is the same, it's a reliable schedule, she will be, in my opinion, children that age, as long as they know it's a routine. This is the routine. This is where I'm going to be at as they get older. Then they don't have any ill effects from back and forth. It's when they don't know any given day of the week where they're supposed to be because there's no routine. It's up in chaos. I think that they have that problem.
All right. Ms. Martin, any additional remarks from you?
Yeah, wouldn't say that she's adjusting any better to the overnight stays. If I'm still having to pull her off every time, the only time she transitions well is when Henry comes to my house and he picks her up and I put her in his car. Any other time, if I have to go over to his house to drop off clothes or drop her off in general, I have to pull her off of me and she's screaming, crying, saying she doesn't want to go. And that to me doesn't seem like adjustment. That seems like it's going to cause issues for her in the future.
May I respond, Your Honor?
You may.
Yeah. Your Honor, my concern is this, and you know, reading Mr. Andrews' report and the statements made to him by Ms. Martin, that he didn't give a lot of credibility to what she was saying. This is not the experience that my client has had. So we think that the schedule, as Mr. Andrews succinctly put it, is that it was more easy to follow on a Tuesday, Thursday over, and then the weekend, every other weekend. And that's what they'd like to do. I think the rotating 223 schedule is really confusing for a child and confusing for parents. So we think the recommendation is soundly based, and we'd like to see it followed, adopted and followed.
The court also believes, after review of the entirety of the report and the file in this case, that this parenting plan is currently in the best interest of this minor child, and the court will adopt Mr. Andrews' guardian ad litem recommendations in their entirety, finding that it is a sound parenting plan, which has been suggested to this court. And I do understand the mother's concern. It is a valid one. However, I think this is something that is worth attempting. And I think it would be incumbent upon a parent to show, after a considerable period of time that this parenting plan has been in effect, to show why the plan is not in the best interest of the minor child. It is not the view of this court that it should block its implementation at this point. I think it needs to be tried. And if there's adaptations that need to be made consistently with the best interest of the child, that can always be done in the future. But for now, the court will adopt Mr. Andrews' recommendations as the orders of the court in regards to a parenting plan. I'm going to place the responsibility of drafting of what I'm going to entitle shared custody decree on Mr. Blanchard. I think this will have an impact on child support, will it not, Mr. Blanchard?
It will, Your Honor. And I had one pay stub from Ms. Martin. I have provided her with 4 pay stubs for my client. She has been claiming the child each year. If that would continue, it would make actually, again, if they'd share the expenses, that would be fine. If she's going to pay the direct expenses, I can do a child support calculation either way. I know that Ms. Jordan said that she has ceased to work, but she does have the capacity and capability to work, and she has a pay stub which would show what she earns. I'm going to, with court's permission, submit a worksheet. And if she wants to claim the child each year, then there's probably going to be no child support obligation. If they alternate the exemption each year, it would be $50 a month based on my calculations for Mr. I'm sorry, Mr. Matlock. And then if they had a shared expense plan, if with her having the lower income that she would pay the direct expenses, then it would be somewhat higher. I calculated that at $127 a month, but with no adjustment for the value of the tax exemption.
All right. Blanchard, I want to make sure I understand what income figure for the mother would be used.
I used what her income was from Walmart. She was working 14 to one pay stub. She gave me $14 an hour times 78.5 hours biweekly. I took that times 26 weeks and divided by 12 and came up with 28,574, which turns out to be 2,381 a month. And my client's income is at $3,200 a month based on his pay stubs. And so I did the calculation based on those numbers, Your Honor. My calculation showed that my client had about 57% of the joint income, and she had about 43%. Let me see. Let me pull that up. I'm sorry. I came up with 57.3 and 42.7. There is no daycare cost. Miss Martin has the child on the state health insurance plan at this point. So that's the calculation I came up with, Your Honor.
All right, Ms. Martin, apparently Mr. Blanchard's numbers are based on income that you had from Walmart, which appears to be a fair number for you. Would you agree with that?
I guess so. I don't work anymore, so
How
that,
do you financially survive without working?
well, my boyfriend,
Okay.
he works and he's taking over the bills since I'm not working anymore and all that.
All right.
Your Honor, per the guidelines and based on her recent income, I simply imputed that amount to her as what she's capable of earning.
Understood, Mr. Blanchard. Is it your intention, Jordan, to continue to pay the expenses for the child?
Yeah, we will.
Okay. I just want to make sure that when you make that representation that you have the financial capacity to actually do it.
Yeah.
And you say you do. Okay. I think that gives you some direction, Mr. Blanchard. And
Yes.
is it your intention, Jordan, to continue to claim the tax dependency benefits for the child each year?
I do plan to.
All right. I think you have that direction as well, Mr. Blanchard,
Yes.
in ultimately completing your child support worksheet.
Yes, Your Honor, I can do that. And what are we today? So would make that effective starting December 1 of 2025, Your Honor.
Yes, and it was really the intention of the court perhaps to delay the start of this plan until December 1st as well, so that the child support decrease and the parenting plan are implemented on the very same dates. And that would give the mother and father a short transitional period while this journal entry is being prepared and circulated, and actually have this go into effect on December 1 of the year 2025.
Okay.
Now, I do understand that there is a holiday parenting plan that would be incorporated into this plan as well. It's a rather detailed plan. It
Yes.
undoubtedly covers Thanksgiving. And so that plan would need to be followed for the Thanksgiving holidays this year, despite
Okay.
the fact that the shared custody plan would be implemented as of December the 1st. Furthermore, if you're going to use exact language, and I would prefer to the extent possible that you do, Mr. Blanchard, when you're incorporating the guardian ad litem's recommendations, he uses the term in paragraphs A, B, and C, should. I'd ask you to change that to shall.
Yes, Your Honor.
These now become court orders rather than recommendations. So I think it's important to change that one term in his text.
As to the recommendation, Your Honor, I can attach the recommendation, but I thought I would go ahead and explain it a little more fully in the order as well. Is that okay? Or just attach?
I don't want the guardian ad litem recommendations attached.
Okay, thank you, Your Honor.
He's got a relatively short actual recommendation section. That should be incorporated as much as you can, word for word, with that one change I ordered. But I really don't want the report becoming part of the order.
Okay, thank you, Your Honor.
Okay. And I do want all current parenting orders, visitation plans, holiday plans, other standard clauses incorporated into one order.
Okay.
Mr. Blanchard.
In one order, okay, I will not file a separate parenting plan. And also the parties were ordered and have been communicating by our family wizard. I want to include that in the order as well, Your Honor.
Indeed, that's an existing order that the court wants carried over. If it's successful, let's maintain what's successful.
I agree.
And that's good communication between the parents.
Okay. Thank you, Your Honor.
I really hope that this opens a period of true co-parenting, a lot of sharing of information, sharing of ideas, just to work together for the best interest of this child. That's what the child deserves.
Okay.
And I hope that you two can continue to work together, recognize the constitutional rights to parent on each side of this case, and then raise this little one successfully. Mr.
Your Honor,
Andrews, thank you for your work on the case.
Thank you, Your Honor.
Your Honor, may I ask one question, please?
Yes.
Every order I've had to submit it pursuant to Rule 170, and Ms. Martins has not signed it. I don't want there to be any delay with this, so I would really strongly encourage her, based on what Mr. Andrews' recommendation is in the court's orders today, to review it and sign it and get it back to me so I can file it promptly.
Ms. Martin, I think that's a reasonable expectation of Mr. Blanchard, that you'll promptly look at it. And if it reflects what we've discussed here on the record, even if you don't agree with 100% of it, if it's what we've discussed, you should sign it and send it back.
Okay. Last time there was not something that was discussed. Well, it was discussed, but you declined it. And then he turned around and changed and added it and gave me an opportunity to decline it as well. But I didn't have the rights or the means to be able to decline it.
Okay.
That's not an accurate statement, Your Honor.
Okay. Well, we're talking about moving forward from here, Jordan. So again, if it's what he sends is a fair reflection of the parenting plan and the orders which we've gone over today, then you should approve it promptly and get it back to him. I don't want
All right.
delays in the implementation of the parenting plan as of December 1st. I want things to go smoothly as of that date.
Yes, and I am so sorry if there was stuff that I was supposed to be signing. I did not know that.
Okay. Well, we want to make sure you're involved in this. That's the whole
Okay.
point. Okay. Very good.
Thank you, Your Honor.
Okay. If there's nothing further at this time, then the Matlock and Martin matter will currently be in recess. Good luck to the parents in the future. This meeting may be ended for all as the court is in recess.
Thank
Thank
you.
you, Your Honor.
Thank you, Your Honor.